Hey everybody, Bobby Kling from Your Online Genius here. It's been a hectic week. Today we are going to finish up the theme week about blogging and the law and legal issues you need to be thinking about when it comes to blogging. Sorry that I missed yesterday. It's been one of those weeks. I set some big, hairy, audacious goals for myself. I've got some big deadlines coming up, and so things got away from me yesterday. At any rate, just a quick reminder of who I am. I'm Bobby Klink. I am an online entrepreneur and an intellectual property lawyer. I work with other online entrepreneurs to help make sure that they have safeguarded the business that they're building online, that their platform is safe, that they're not stepping on legal landmines, basically that they're doing things right legally as they build their business. And so that's what I do. In my practice as a lawyer, when I was, which I still do, I have a law firm where I work with clients one-on-one, which is called Klink LLC, but I kept seeing a common theme, which was that entrepreneurs were making mistakes early on before they could hire me or any other lawyer because it was at the startup phase. And let's be honest, hiring a lawyer is expensive. And so they were making these mistakes, and the problem was these were mistakes that any lawyer would kind of immediately see and say, hey, we got to fix that. But you would only see it if you were really in their business. And non-lawyers wouldn't know these were problems. And it was the kind of things that a non-lawyer just might not even think about. But the problem was these were the kinds of mistakes that could really doom their businesses later on. Not just things that, okay, it's a little blip, but they could fix it later. In some cases, they could get fixed. But in some cases, they couldn't be fixed. And so that's where Your Online Genius came from. This is a business I built to provide education, resources, courses, etc., to help online entrepreneurs protect themselves before they're to the point of being able to afford to pay a lawyer. There are all kinds of benefits for entrepreneurs who learn this stuff early on because, look, aside from actually protecting yourself, it's going to make you into a better client later and more knowledgeable, and you'll be in more control. But the idea is to give you do-it-yourself resources. So that's who I am. That's what the company's about. But as I mentioned at the outset, we are wrapping up our theme week where we're covering blogging and the law. And today we are going to be addressing a specific issue, and that is guest posts. And maybe you have guest posts, maybe you don't yet, but the question is, if you allow people to contribute to your blog, do you have written agreements with them? Do you make them agree to something in writing about that guest posting? If not, you're making a mistake. And the reason, there's a couple of reasons, but fundamentally it comes down to the fact that you don't then know what the agreement is. What have you agreed to with these contributors? Have you agreed that you'll post their content on your blog but nowhere else? Have they given you permission to use it in other places? Without an agreement, you don't know. And the problem is that without an agreement, so to be clear, they have copyright protection in the work. They wrote it. And once they put it down into fixed form, they have protection in it. So I don't think you're going to get, I shouldn't say I don't think. You will not get in trouble for posting the material on your blog that they give to you for that purpose. Because even though they have the copyright, by sending it to you, they have implicitly said, yes, I want you to post that there. So you're not infringing their copyright by posting on your blog. But I want to be clear, you don't own the material. They own the material. They have given you, theoretically, an implicit license, which just gives you the right to use it in a certain way. But the contours of that are not clear. They're not clear because there's no agreement. And with your blog, if you think about it, some of the great things you can do when you get guest posts is later on you can repackage that and use it in other formats. Maybe you create a lead magnet where you collect the 10 best pieces of advice from your guest posts or from your experts. And you could do that and put it together. But the problem is, without a written agreement, your people who've submitted guest posts haven't given you permission to do that. They have not told you you could repackage their material and use it for another purpose. So then, if you're not getting written agreements with folks, you're going to have to go back and try to get their permission later on. And hey, maybe they give it to you, maybe they don't, but do you really want to have to go through that hassle? What if you can't find them? What if it takes some delays? You just don't want to have this problem in your business. And the way to solve it is very simple. Get a written agreement that sets out what the deal is between you and your contributor. And you could imagine there are various different deals you could strike. One deal would be that they are transferring all rights to you, that they don't even own it anymore, that they're giving you the copyright. That's one deal you could strike with people. And again, most people who are looking to do guest posts would have no problem with that. And they'd have no problem with that because their point in getting the guest post is to get exposure on your blog for their blog and get your audience aware of them and aware of their product and aware of their services, and then to go to their website. They might be trying to get backlinks to their site for SEO purposes, but it's not really, they don't care who owns the material at the end of the day. Again, hopefully you're only having people do guest posts if that guest post is unique. You don't want them posting the same thing on 18 different websites. So, that's something in and of itself. But that's kind of the most extreme example of asking them to transfer everything. What you might do instead is simply have them sign an agreement where they give you rights, a license to do anything and everything with it, to use it for any purpose, including your blog or any other future legal, purposes that are legal under the law. And if you get that kind of agreement, you're good. You can repackage, you can do whatever you want with it, and you don't have to go back and ask for permission later on. So that is probably the deal that you'll want to strike with most people, because again, most authors, people who are writing their blog posts, they probably don't want to give up ownership, and you probably don't care about owning the content. You just want to be the one, or have a right to use it for whatever purpose you want in the future. So you should get that kind of agreement with your contributors. Now, you might be saying, okay, fine, but why do I have to get a written agreement? Well, you have to get a written agreement because rights and intellectual property can only be transferred by written agreement. So you need a written agreement to make sure that you have the rights. But more importantly, if you don't have a written agreement, and this isn't limited to this area, I talk about this over and over and over again. If you don't have written agreements on kind of any agreement that you believe you have in your business, you are asking for a dispute. You're asking for a dispute because people's memories fade. And let's be honest, a year from now, everybody will tend to have a memory that favors them. I'm going to remember myself as the star of the show. You're going to remember yourself as the star of the show. That's just the nature of the way people are. And so what's going to happen is if you have a business agreement, the same thing's going to happen. Each party is going to tend to remember the agreement as favoring them a little bit more. And so you can end up with different understandings of what the agreement was. And then, well, how do you figure out what the actual agreement was? There's nothing you can cite to. There's nothing you can look back at. There's nothing you can do. So you are asking for a dispute if you don't put these things in writing. And there's all kinds of other problems with asking for a dispute. You're going to destroy relationships, right? Because if the two of you end up with a different belief about what the agreement was a year down the road, what's going to happen is either you're not going to be able to come to an agreement at that point, and that's just going to sour things because both parties are going to be mad, or one party is going to come around and begrudgingly agree to the other person's belief, but then the person who gave in feels slighted and feels upset, so they're not happy. So it just destroys relationships. Whereas if you have a written agreement, boom, clear, no questions, there's a dispute. Well, hey, look what this agreement says. It says I can do X, Y, and Z. So that's what I'm going to do. And that's the end of it. So that's why you want to have written agreements. But let me give you a phrase that I like to use that should be the best reason for you to get written agreements for this and for every other part of your business. Written agreements are lawyer repellent. And that may seem weird coming from somebody who's a lawyer to suggest that to you, but let me be honest, you don't want to have to deal with me professionally in a dispute situation. You just don't want to do that. You want to do everything in your business to avoid having to deal with me or someone like me in the future. And I want you to do that too, because I don't like coming in when things have gone south and have gone sour. But that's what will happen. So think about these agreements as getting lawyer repellent, keeping me away. Think of it kind of like, an apple a day keeps the doctor away. Well, an agreement a day keeps the lawyer away. So what I would commend you to do is get written agreements everywhere in your business that's important. And that way you will know that you're safe, you're not asking for a dispute. And in this context of the guest posting, it will give you the freedom to use that material any way where you want for any purpose, and you don't have to think about it. So get those agreements in place. That's it for today. That's it for this week. Next week, I'm going to do my best to do these lives. The theme for next week is list building. But candidly, I'm going to have a couple of days where it's hard, or I may not be able to, because next Wednesday I'm heading out of town for my 5-year anniversary. My wife and I got married down in the Bahamas. We had an unexpected guest in the form of Hurricane Sandy, but we're heading back to where we got married for an anniversary with some family. So, I should have Wi-Fi, and I'm hoping to be able to continue to do these things, but I won't know for sure until I get down there whether I'll be able to. But I will definitely be here Monday and Tuesday talking about list building and legal issues with list building. So hopefully you'll be able to see that content, and I'll be able to continue to post on Wednesday, Thursday, Friday. But until then, I hope you have a great weekend. If you're enjoying this content, and if you'd like to kind of get more and take a deeper dive into mistakes that you might be making in your business, you can get your hands on my free cheat sheet, which covers kind of the 4 biggest mistakes I see online entrepreneurs make. And these are kind of big picture mistakes that you might be making in multiple parts of your business, in blogging and podcasting and just about anywhere. But it's kind of 4 big areas. And so you can get your hands on that at mistakes.youronlinegenius.com. Again, that's mistakes.youronlinegenius.com. And you can get that cheat sheet free and figure out if you're making these mistakes and what you need to be doing to avoid them. So until next time, have a great weekend, and I will see you next week.